All right, my name is Matt Davis, and I am Executive Vice President at Maranatha Baptist University. But more importantly for this session, I am Corporate Counsel, and I am an attorney. I was the staff attorney at the Christian Law Association for about 10 years. Some of you may be familiar with Dr. Gibbs and that organization. In my time there, I was the Christian school lawyer, and if you know anything about CLA, that's kind of our bread and butter. And so had the privilege, may have talked to some of you over the years. If so, don't worry, I've forgotten everything that we talked about, all right? I won't hold it against you at all. I love to do training sessions like this because I think it's so much more important to learn in an environment like this than it is to learn in the courthouse, because a lawsuit is only interesting when it's happening to someone else, right? Kind of like surgery, you know? And so we want to learn well, we want to prepare well, and I believe that this will be a good session for that. Tomorrow morning, first thing, I believe all my sessions are in this room, but tomorrow morning, first session, we will do the Children's Protections Ministry training, and you'll want to get in on that. This is a training that I'm going to, that I've prepared and done literally hundreds of times. It's always updated, it's always new with the new threats. But this is something that your staff should be aware of. This is a type of training that you constantly need to be refreshing and that they need to be aware of. So you should be here, at least get that way. Encourage some of your staff to come, and I believe that'll be a blessing. We're going to focus as well in the morning on kind of a hot topic area in terms of child abuse reporting. And there have been some changes in some of the states that have been represented here at the Great Lakes Convention. And so you'll want to be a part of that for sure. And then my third session is kind of an interesting one on social media and the law. Let me see who we have here today. How many of you are the administrator or principal at your Christian school? All right, very good. And another form of leadership at the ministry, maybe pastors or other kinds of leaders, good. And how many of you are teachers? All right, probably some that do a little of both. That's great. And so have you noticed that social media gets a little bit now as kind of an issue, you know? I can remember when I first started in practice at CLA, there was no such thing. You know, we were collecting email addresses, and about 10% of people had email at that time, you know? And boy, have things changed. And my contention with social media is that it is not creating the problem, it is revealing some things that were there all along. And so we want to be properly prepared to respond to that and deal with that within the ministry. So that session will focus on social media. That's what that's all about. Now, this afternoon, I'm going to bring you up to speed on three major areas of, I'm going to call them threat. I think that more likely they're areas of legal challenge that we're going to be facing and are already facing. The first that we're going to talk about is marriage being redefined. All right, so we'll look at the Obergefell decision from the Supreme Court, and in the year and a half-ish since then, some of the fallout that we're already beginning to see from that decision, which we predicted would be the case. And then we're going to look at, change gears completely and look at the Affordable Care Act, which I like to call the Not So Affordable Care Act, as we are finding out. And come to find out, even former President Clinton, I wasn't making a prediction, all right, former President Clinton has admitted is failing and crumbling around us, but it has some major and sort of drastic consequences for ministry. And then thirdly, we will look at the new labor laws that are coming into effect, and some of you may be aware of that. You need to be aware of that because all of that kicks in on December 1st. And this is one of those things that Obama has put into place without any congressional act, without any legal other underpinning, simply by administrative order, and yet it's going to have some pretty major impact for ministries. So we're going to look at those three issues today, and hopefully that will be a blessing to you. So first of all, marriage redefined. Now, the truth is that marriage cannot be redefined because marriage was not defined by the law. Marriage was defined by God. Would we all agree with that? And that the law cannot redefine something that God has already determined. And so, technology doesn't want to cooperate. That's all right. We will bend it to our will, all right? Marriage was defined by God in the Garden of Eden. And we understand that God created marriage, and He created genders, and He created those classifications of the human beings that He created. And so the Creator has certain rights, and the rights of the Creator are to define the rules. And we teach this to our children, don't we? It's so simple. And yet our society is completely rejecting that very fundamental principle. By the way, there's a group called Answers in Genesis, and they sure are right about a lot of these things, are they not? And so we understand that it was created by God. And even in the New Testament, we see that God uses marriage to picture His bride, His relationship with His church. And we find that in Ephesians chapter number 5, 31 through 33. It says, a man shall leave his father and mother and cleave unto his wife. And then he goes on to say, this is a picture of Christ and His headship over the church. The problem, theologically, with redefining marriage is that you're also redefining the picture that God created to show us about His relationship with us as believers. That's one of the reasons why this is a major theological issue. You'll hear many people say, well, it's not that big of a deal. You know, how does that affect you? It doesn't affect you if we go ahead and redefine it over here. Well, when it's defined by God, it has a major effect. All right, now, what is God's definition of marriage? Well, let's break it down. We find this in Scripture. We find this naturally. Marriage is the permanent and comprehensive union of one man and one woman dedicated to each other for life in an exclusive relationship focused on raising children. Now, we're not going to get on side lights about, well, what if a couple never has children, or what if somebody never gets married, and all of those different questions. But the fundamental, really unarguable basis for marriage is God's design. It encompasses these three areas that I have underlined. That it's to be permanent. That God did not design marriage to be sort of take it or leave it, let's give it a try, glib, right? And that God defined marriage to be permanent, lifelong. And that's what the Scriptures clearly teach. It is comprehensive. Now, by that I mean it affects every area of your life. Now, those of you that are married in the room, would you agree with that statement? Marriage affects every area of your life. There's not an area of your life that's not touched by the marriage relationship. It is comprehensive. It is exclusive, as defined by God. That marriage is meant to be the exclusive relationship of one man with one woman for life. And that is what is under attack. And so we find that with marriage intended to be permanent, and marriage is described in the Bible as a one flesh union, what's being described there is that comprehensive nature. Now, what we find then under attack legally is all three of those areas. Of course, we all know that, by now that last June, the Supreme Court, we call it SCOTUS, those of us in the legal profession, Supreme Court of the United States, if you ever wonder what that means, reversed all of human history, not just American history, but all of human history, and said that, and I'm quoting from the opinion here, in forming a marital union, two people become something greater than once they were. As some of the petitioners in these cases demonstrate, marriage embodies a love that may endure even past death. It would misunderstand these men and women to say that they disrespect the idea of marriage. Their plea is that they do respect it. They respect it so deeply that they seek to find its fulfillment for themselves. Their hope is not to be condemned to live in loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eyes of the law. The Constitution grants them that right. That was Justice Kennedy, the fifth and deciding vote in the Obergefell decision. That's the operative language of the opinion. Now, I find it interesting, Scalia's dissent, may he rest in peace, right? Justice Scalia, in his dissent, says, if even as the price to be paid for a fifth vote. Now, what is he referring to here? he's giving us a glimpse of what the justices do behind the scenes at the Supreme Court. This is a process that is completely closed door to any normal human being. We have no idea. There have not been books written. They won't tell us. But there's a lot of horse trading that goes on behind the scenes. And it's the idea that we'll bargain on what the language of the opinion will say eventually in order to get people, enough justices, to sign on so that we become the majority opinion. And so let me read to you how the opinion starts out, because this is what Scalia is talking about. The first phrase, the first sentence of this opinion is, quote, "The Constitution promises liberty to all within its reach, a liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity." Hogwash is what that is, okay? By the way, that phrase, that sentence drives lawyers nuts because it's so meaningless and trite. And that's what Scalia is representing here, because he says, if I ever joined an opinion for the court that began like this one, I would hide my head in a bag. I like that. Very seldom do you see the justices opening up and being that candid about something. The Supreme Court of the United States, if you've ever been there, it's amazing. It's magnificent. It projects power just even through the building itself. And here they are. He says, this great Supreme Court has descended from the disciplined legal reasoning of John Marshall and Joseph Story to the mystical aphorisms of the fortune cookie. And that's what we have ended up with in this opinion. It's almost as bad as Roe v. Wade in terms of its complete lack of any legal basis whatsoever. Even the people that agree with the outcome admit there is zero offered in terms of legal precedent or legitimate analysis offered. It's all on this sort of, I feel like this is where we should go kind of a basis. So why is this such a threat? Well, let me give you 3 new words that have emerged just before and now after Obergefell. The first is throuple. No longer is it a couple. We now have people pushing for the throuple. And that would be the idea that the number 2 is no longer sacred. Now, this was pointed out to us in several of the dissenting opinions. In fact, Justice Roberts, who was on the right side of this one, said, one immediate question invited by the majority's position is whether states may retain the definition of marriage as a union of 2 people. Although the majority randomly inserts the adjective 2 in various places, it offers no reason at all why the 2-person element of the core definition of marriage may be preserved while the man-woman element may not. And so he pointed out that, guys, we're going to see cases now where people are going to want to have on the same basis, if it's all about who I love and my right to identify with whatever I am, we're going to see cases pushing for the legalization of polygamy and bigamy. By the way, he wasn't wrong. So in preparation for this workshop, I decided to find out how many of those cases are pending now. We have one that's already worked its way through the appellate court system in the 10th Circuit. By the way, does anybody know what state the 10th Circuit covers? No, that's the 9th Circuit. Utah, ding ding. So guess why a polygamy case might come through the state of Utah? Sure enough, have you ever heard of the TV show Sister Wives? Right? The idea is a man named Cody has about 5 or 6 different women that he is married to, and he was threatened with prosecution because of some complaints that came into the prosecutor's office after people saw this TV show and said, hello, I think we found one. He's gone on TV. Why aren't you prosecuting this guy? That's illegal. And the prosecutor said, kind of a good question. I'm going to look into it. Based on that threat, Cody Brown sued the state of Utah. And he said, I'm being threatened with prosecution. And based on Obergefell and that reasoning, these laws are unconstitutional. And so that case has come all the way through now and is heading to the Supreme Court. Now, here's what's interesting. The case was dismissed by the court, and at the 10th Circuit, reversed the lower court and dismissed the case completely because it said, it didn't say it was because of the fact that Cody didn't have a case. It was dismissed because the prosecutor put forward their new policy. You want to know what their new policy was? Let's see if I can find it here. I have the language here. I might have to look it up right here. All right, let me see if I have it. Yep, I got it right here. So here's the new policy from the prosecutor's office in Utah. The Utah County Attorney will bring bigamy prosecutions only against those who, number one, induce a partner to marry through misrepresentation or fraud, or two, are suspected of committing a collateral crime such as fraud or abuse. So what they're saying is, he doesn't have a case, Your Honor, because we are not going to prosecute any regular polygamy or bigamy cases. As long as the wife isn't underage and as long as she's not tricked into the marriage and does this knowingly, we will not prosecute. So the 10th Circuit said, oh, you don't have standing anymore. This case is no longer an active case. That's the only reason they threw it out. Let me tell you something. That's not a defense of marriage. That's not a win for traditional marriage. That's a sign that this has become so much a part now of assumed practice that they throw the case out altogether. So that's a problem. Throuple. Number next, monogamish. Monogamish. We had monogamy, which was the idea that we were going to be committed to one another. That's that exclusivity idea. And now it's sort of like, we're going to have an open marriage. Now that's not necessarily a new thing, but what's a little bit new is how mainstream this has become. And the idea of having a sexually open marriage and having that kind of a relationship is now right out and in front. And then the final one that's been kind of interestingly proposed by those who love marriage so much that they want to have a part of it, as Justice Kennedy said, is wed lease. We had wedlock, but that's so restrictive, right? That's so confining. Let's just try it out. And so instead of even making a vow, even pretending that this is going to be forever, let's just set it up for like a 5-year test run and see where we're at in 5 years. And the idea is that you could have marriage for a specified term that automatically ends unless it's renewed by both parties. This is the idea that's put forward. You see what I mean by redefining marriage? This is what we're after. Now, let me just say, I've thrown on there now sort of the fourth battleground area, which is unquestionably here right now, and that is the transgender rights. In my town, in Watertown, Wisconsin, our public school district has been embroiled in this. I'm sure that you have seen it in your community as well, because state departments of education are starting to put out the mandates to their public school districts that they must accommodate the gender identity preferences, including pronouns, restrooms. By the way, there are over now 180 different recognized pronouns. Instead of just he, she, it's now she, and you can be, there's even one young man in a college in, where was that, out west, who's won the right to be called Your Royal Majesty as his preferred pronoun. We have people identifying as attack helicopters, and the idea is common sense no longer exists in these arenas. The idea that a young man in high school might decide to hang out in the girls' bathroom for maybe some other reason than his gender identity crisis never occurred to these folks. And the idea that you as an educator ought to be able to have some common sense in saying, wait a minute, this is not what God designed. This is not what we're going to have. And so this is the battleground area. You say, yeah, but we're a Christian school, so we're pretty much immune to that. I wish it was true. Let me give you some of the biggest threat areas. Number one is funding. The first line. I see these as if we were defending a castle, and we're not. I don't want us to ever even get the castle mentality, okay? Because that's not what the Great Commission is all about. It's not about sheltering in place until the Lord returns. No, we're supposed to advance the cause of Christ. And I realize Occupy Till He Comes has sort of a standing still mentality, but, but that's not the ultimate idea, right? We're supposed to be impacting our culture for Christ, and we can't do that from behind the walls. So, but bear with me. If we were in a castle, we'd have concentric rings of defense, right? And these attacks would come sort of in waves. And I see the attacks kind of coming in these waves. The first is any sort of government funding is conditioned upon non-discrimination, which, I mean, hey, how could you be against non-discrimination, right? I mean, that's a great buzzword to use. Well, the problem is they're using civil rights era language and adding to that, you know, where you had color and race and gender and now sexual orientation, and the new one, which is gender identity. Not just your God-assigned sex, but your decision to live as something other than your God-designed sex, your gender identity. And they're wanting to add those in. That has not happened federally. It has not happened. But everyone is acting like it did. And that's what is so unbelievable about where we find ourselves legally right now. And so we find ourselves in this first cycle. You say, well, we don't take vouchers at our school. We're not a charter school. Okay, great, good for you. But what about the school lunch program? That's considered funding. We have no doubt that this is an area. You've got to have those connections with your legislators. You have to be involved. They have to hear from you. The next one is tax-exempt status. The Bob Jones University case from the 80s that had to do with race discrimination and the loss of tax-exempt status over race discrimination did not say that you lose your tax-exempt if you have racist policies. That is not what the case said. It said you lose your tax-exempt status if you have policies that violate established public policy norms. And race is one of those. Now, there's only ever been one other thing added to that list, and it was intentionally inciting violence or the violent overthrow of the government. So the KKK and some of those hate groups like that. It's the only other one that's been added to the list. But ever since that case came down, we've been saying, now it's all set. It's all in place. Everything they need is in place. And it's just administratively now. The IRS just has to decide that it's clear public policy that if you discriminate on the basis of sexual orientation or gender identity, that you are no longer tax exempt because that violates public policy. I have to tend to agree with them at this point based on what you see on television, in the media, on the news, now in the courts. How could you not say it's public policy at this point? I mean, there isn't a segment of society that's still holding the line on this, except a very small percentage of the faith community. See, we're sitting here thinking, oh, well, we're part of the churches will stand together, they won't let this happen. Most of the churches out there have already long since given this up, including many of the Orthodox churches that you would think of that would be standing with this. They're not. They're not even pretending to. So we are being sheltered into ghettos, as my friend Mike Dean and I usually talk about, just like Jews pre the Holocaust. And the idea is, as long as we can identify this group and assure everyone else that they're going to be okay, then we can exterminate them. And I believe that's exactly what's happening through these concentric circles. The third one is the biggie. Oh, by the way, it's not just federal, it's state. So you have sales tax exemptions at the state level, along with state income tax, and you have property tax exemptions. Every one of those things will eventually be targeted for elimination based on this issue. The big one is the final wall to attack here is public accommodation. And this happened in Iowa not too long ago. Last summer they messed up and they went a little too early. And so they were beaten back pretty severely. But it reveals exactly what's in the playbook. And they just did it too soon. And what they tried to do in Iowa is that they said, oh, you churches are public accommodations, and you must therefore have a non-discriminatory policy on gender identity and sexual orientation. And don't worry, that doesn't violate your faith because we're only applying this to any services where the general public can attend. And I thought, oh, like all of our church services? I mean, think about what they're saying there. You can have a members-only meeting where you all get around and discriminate. That's fine. But the minute you open the doors to the public, now you have to have a non-discriminatory policy. and allow people to use whatever restroom, etc. So how does that work on a Sunday morning? How does that work in a Christian school that says, you can come here and bring your kids to your community? Any kind of outreach ministries are impossible under that standard. And so they quickly retracted that after some serious pressure and a lawsuit from ADF. But they backed off. But I believe it reveals exactly what the next play is in the book. All right? So that's what to expect. So what can we do? Well, AACS is suggesting, Jameson Coppola, and you read the stuff that he and their group puts out, are very much in support of something called FADA, F-A-D-A. And it's the stupidest law that ever was suggested, that there ever needed to be such a thing. Okay? It offends me as a lawyer that we need to have a law called the First Amendment Defense Act. Because the Constitution is the supreme law of the land. It doesn't need to be defended by lesser laws and acts of Congress. And yet here we are. And so what does FADA say? It says that a religious organization cannot have funding or tax-exempt status or public accommodations conditioned upon its relinquishment of its Bible-based views on marriage. Okay? That's what it says in a nutshell. And so I'm urging you to support FADA, talk to your legislators. It has tons of co-sponsors in both chambers of Congress, and it will go absolutely nowhere in this term, I promise you, because nothing is going anywhere in this term right now. But if they can get on board with this, it can get to the floor as soon as we have a new president seated. Now you say, do elections matter? Big time, big time. And so this is a major issue that stands there. There was a FADA that was passed in a southern state. I can't remember if it was Alabama or Mississippi. I think Mississippi. And it was struck down as unconstitutional by one of their state courts. Go figure. And so they've made some tweaks that they believe will rescue its constitutionality. But we have to understand, we're up against a very heavily motivated, heavily financed, and entrenched opposition here. And so our hope has never been in the law. Our hope has always been in the Lord. And as much as this is very depressing to me and many of us as we study these things, we understand we're just as much in the Lord's hands of protection as we always were. And this is just helping us to see that more clearly, is it not? All right, so those are the threats to the schools. What can we do as a ministry to properly prepare and respond? Well, number one, we need to exhort and effectively teach the Bible and its foundation and meaning for marriage. That is the number one protection. The strongest aspect of our defense is people understanding and learning God's Word. It's powerful. It has a power beyond our own ability. Number two, we've got to have clear definition of our statement of faith. The Boy Scouts case is still on the books, even though the Boy Scouts have changed their policies, right? The early 2000s, the Supreme Court said, if you have in your governing documents protections that are, or statements that show that these are foundational, religious, Bible-based beliefs, then you are protected as a private organization in making hiring and firing decisions on that basis. Notice, they did not say because you are a religious organization. It was not on that basis. It was the freedom of association that they made it on that basis. And so in order to establish that, it needs to be clear in the foundational documents. Now, it has to be clearer now than it ever had to before. And by that I mean we end up putting things in there that you'd be a little bit of, you'd blush a little bit to have your junior hires read. That they'd even have to go to this level of specificity about where your ministry position is on matters of sexual orientation, sexuality, pornography, things like that. Employment criteria, major battleground area. Again, it's got to be clear. One of the only and last defenses we have are our religious liberty rights, where we say we as a ministry hold this as a Bible standard, and then you have to apply it in the realm of employment. Apply it in the realm of your facilities use. Apply it in the realm of your admissions criteria for your Christian school. In your code of conduct of what you expect of your young people. One of the cases that I had came from a southern state, and they were sued because of a discipline issue where a young lady and another young lady had a sleepover, and they decided to engage with some kissing and different activity there, but short of intercourse type of activity. The school dismissed them for homosexual conduct. And the case was, if a guy and a girl had engaged in kissing and this kind of behavior, you would have suspended them or punished them with something lesser than expulsion. But because it was two same-sex actors, you decided that was more serious. And so you expelled them. But where does it say that in your documents? Where does it say that in the handbook? That you treat this kind of behavior more seriously because it is two same-sex students. You say, well, we just have a clause that says no immoral conduct. Yeah, you and 90% of the Christian schools out there. The problem is, what used to be kind of logical as immoral conduct, there's no such thing as a logic to that anymore. You have to be more specific. Facilities use is a big one. If you allow your facilities to be rented out to community groups, then what are you going to do when a local gay rights advocacy group tries to push a test case and come and rent your facility in order to plan their entry in the parade or whatever it is that they want to do? So you need to be careful about that. My personal recommendation is that you not rent the facility out on a general basis. That you reserve it, it's there for your members, it's there for your ministry, it's dedicated to the Lord's work. You just need to keep it sanctified that way. That's my personal belief on that. Church membership policies, and then even ultimately a marriage policy. And this is two facets. Who can get married in our church, and who can our pastors marry even outside of the church? So many churches have been caught on this because they forget about that second prong. If you have an assistant pastor and he has a family member who's wanting to get married, is he allowed to participate in that marriage if it is a same-sex marriage? What are the consequences of that? Notice all just these kind of secondary issues that keep rolling off of the main issue. And so you need to think all of that through. Now, there are some fantastic guidelines and resources out there. The Alliance Defending Freedom has published a kit, a handbook that covers every one of these and gives suggestions. I highly recommend that you download that. If you want that, I can send it to you myself. If you want to send me an email, I'd be glad to do that. All right? Okay. Any questions, by the way, about any of these issues? I'll open it up. Yes, sir.
What would you say about prospective members coming and you handing them your church policy or whatever? It's kind of a gray area for me because some folks, they see that and they just run away.
I have no interest in making myself a target.
Thank you.
Okay? Really have no interest in making myself a target. And we've even had, at the college, we've had advocacy groups contact us, want us to be a test case for this or for that. I said, man, I'm entrusted with 1,600 young people in their higher education. I can't go risk that over your issue, your crusade, right? I think we need to be careful about that. At the same time, if God calls me to be in a case like that, then we will defend the faith, right? We've already determined we're not going to compromise regardless of the cost, okay? And we're not promised that there won't be persecution. I think we're actually promised the other, okay? So if it comes, so be it, but I'm not going to lead with my chin, right? Now, if there's something about that that's giving you a feeling that this isn't a situation that's legitimately someone actually trying to join our church, but rather this is a setup, then by all means, you don't owe them those materials, okay? But you do have to be clear to prospective members where you stand, or else your policy won't be all that effective either. So at some point, yes, you're going to have to share it. I wouldn't put it on the website necessarily.
Like a prospective member's class, maybe, or something.
That's the best way to work through it anyway. I mean, the idea of somebody, and I know in the past, sometimes it was like somebody comes forward, they get baptized, they join the church, they got saved and baptized and joined the same day. I mean, it was great. But I think now we're in more of a mode of discipleship and a new members type of a class, and let's get to know you and make sure this is right. Because here's the thing, membership is valuable. That's not my session today. I got a whole other one on membership, but don't give it away cheaply, all right? Be careful, because under the American law, legal rights attached with members that don't attach to the general community. So be careful about that. All right, good. Let's move on. I want to talk to you just a little bit about the Not So Affordable Care Act. All right, especially 2 reporting requirements that you may or may not be aware of. Fortunately, most of them will not apply to you. All right, so you're going to be okay if you're not huge, but I just want to bring this to your attention. There is an individual mandate wherein a report has to be given to the IRS, a list of all employees with ACA compliant coverage. And that this is a February 1 deadline. The form there is 1095B, okay? You have a deadline on that. There is no small employer exemption. This is generally, if you have a payroll company, they generally take care of it for you. If you have group health insurance plan, they generally take care of it for you. If a group plan is offered, no report is required. But if you if you don't have them on a group plan, then you may need to check into whether or not this particular report needs to be filed. This is sort of like the W-2 that you file with the government and give a copy to the employee. Same thing now with the health insurance. It's the way the government is finding people that do or do not have compliant coverage, okay? So I bring that to your attention. If you do have a group plan, then the insurance company is probably filing the report and you're probably fine, but let's not mess around with these, okay? They're looking for people to make an example of. The second one is large employers, and I just mentioned this. Most churches are too small for this. This one has a February 28th deadline, and I think you have to have more than 50 employees. I believe that's where the line is. 50 employees in order to hit this one. And it's much more involved than it has a February 28th deadline. So if you have more than 50 employees, which by the way is not FTE, it's head count. Okay? You know the difference there? So that would count part-timers and everybody into that load, all right? And if you're a church school, it would be employees of both entities together if you're under the same umbrella, all right? Now, here's something I want to bring to your attention. Premium reimbursement. Now, it gets technical, but let me just tell you the basics, okay? The Affordable Care Act is all about raising taxes, okay? It's all about raising taxes and taking over every aspect of life, but we won't get into the second part. But what they have done is that they have converted previously non-taxable benefits and turned them into taxable income. That raises taxes without people even realizing it, right? And so if you had a premium reimbursement program, which a lot of ministries did, where they flipped over and said, okay, we can no longer afford to have a group plan because the Affordable Care Act literally did not work. I mean, plans have gone through. Ours at Maranatha went up 38% this year. So here I am, you know, with the employees to say, we could have given you a very substantial raise this year, but we can't because you're getting the same health insurance you got last year. It's just costing us 38% more. Now, I don't know what's going to happen next year and the year after that, but a lot of people have eventually been priced out. And so they say, listen, we had this money set aside for insurance. It won't buy insurance anymore. We'll give it to you. You can go on the exchange, or you can go with a brotherhood type of a program, Christian Medishare, or some of the other options that are out there, and you can find your own. And a lot of people are able to find their own. The only reason I bring that to your attention is because it used to be you could do that through a healthcare savings account and it was not taxable income. Now it's taxable income. Okay? So it's where we're at, but I want you to know that was a change. So converting reimbursement plans to taxable does not make them compliant with the ACA. So again, they have to still go out and get their own compliant coverage. There was a transition relief period that they put in there. That has now expired as of June 2015. So what is what are we left to do? Well, rather than calling it a healthcare reimbursement, the only thing left is to just increase the wages by that amount and do the withholding. Okay? That's the only solution left because they won't let us tie it to who used to have insurance and who didn't. Okay? You can't do that. That's an illegal act under the ACA. All right? So those are just some things I wanted to bring to your attention about the Affordable Care Act. It's thousands and thousands of pages. We're not going to get into all of that today, but I thought I'd bring that to your attention. Okay? All right. Last area new overtime rules. December 1, this one takes effect. We have two, when it comes to overtime, minimum wage and overtime, there are two tests. There is a duties test and there is a salary test. The two have always existed. It was last updated in 2004 under George W. Bush. The duties test has not changed. This is where you had to look and see, is this individual an administrator, an executive, a professional? Do they fit the criteria? Do they supervise employees? Do they exercise discretion and care? And so it had all of that. There were no changes made to the duties test. But the feeling of the administration was, too many people are being labeled as exempt from minimum wage and overtime, even though they're not really getting paid enough. And so in order to narrow the exemptions, they left the duties test alone, but they changed the salary test. And I'll talk about that in just a moment, but I want to remind you of some things that have always been the law that didn't change, but that in my experience, you may or may not know, okay? So the good news, pastors are exempt. Clergy serving as clergy are exempt, okay? Now I say that because job titles don't count. Just calling someone a minister does not make them clergy under the definition. So people heard this back in the day and they said, oh, ministers are exempt. So you are no longer the secretary, you are now the minister of paper administration, okay? You're not the janitor, you are the minister of cleanliness. After all, cleanliness is next to godliness. That's not in the Bible. All right. The idea was, let's just give them minister job titles and they'll be magically exempt. Does not work. You have to be qualified as a minister, which in our context usually means ordained or licensed, and you must be serving in that capacity as a minister. Performing what they call the sacerdotal functions. Again, I don't want to get into all of that, but it's basically marry, preach, bury, baptize, do communion, the Lord's Supper. Now, some other faiths, it's hear confession, and they've got other things. I don't know, handle snakes or whatever else they've got going on. But for us, those are the big five, okay? So if you have someone that's, you're calling a minister, but they never preach, they never do these other functions, they may not fit under the clergy exemption. They might fit some other one, but not the clergy. Again, teachers serving as teachers are exempt. That does not include study hall monitors. It does not include people who are not trained as educators. That's a biggie. If someone has a high school diploma, but they've been teaching in your school, they're likely not going to qualify as exempt. They've got to have, under the rules, either a 4-year degree or some higher education and professional experience that is sufficient. Now that's not specifically defined, but if they've been teaching for 20 years and they're a really good teacher and you're happy with them, I'm okay with that. Where I'm not okay is when every single teacher in the school is one of those otherwise qualified exceptions. We don't have anybody that fits the test normally, right? So teachers serving as teachers are exempt. Secretaries, support staff, monitors, playground monitors, and so forth, they never were exempt. That's not a change, okay? All right, so where do we go from here? Here's the change. The salary test was changed. It was, does anybody know what it was? What the old exempt salary test was? $24,000 a year. So they had to make $24,000 a year. Again, that's annualized. So if you have 9-month contracts with teachers, probably was somewhere around $18,000. But they reset the wage requirement to now the top 40th percent, and it's $47,476 a year, and it's going to go up every year with the cost of living increase. So that dumps a whole lot more people into the potential for overtime than were never there before. Now I should mention, you're saying, because I can't pay the teachers $47,416 a year. I understand that. Teachers are still exempt, even from the salary requirement. You say, great news. Wait a minute, what? Oh. It's good news, bad news situation, right? Clergy, still exempt from the salary requirement. But if you had other people in those other categories, administrative, executive, professional, they have to not only meet the duties test, but they also have to be paid at least $47,500 approximately a year. If they're not, then you have to track hours, meaning clock in, clock out. You have to pay for every hour worked. They can't volunteer to do what they get paid to do. And you have to pay time and a half for all hours worked over 40 in a 7-day work week. It doesn't average out over the year. It doesn't average smooth it over the month. It's a 7-day work week, time and a half. All right? So support staff, administration that doesn't teach, those rules are probably going to apply. Okay? So you say, well, what am I supposed to do? Get creative. All right? I have 5 different paths that I've designed at Maranatha where we're looking at all of our employees. And I've got 35 people whose positions are going to change one way or another because of this situation. And we've kind of narrowed it down to that from 200 plus that we started with. So we've been working on this for a year. And if you're hearing this for the first time, tally ho, you got till December 1. Okay? That's when all of you say, well, how are they going to find me? They don't have to find you. Your people will volunteer you. All right? You ever heard of a dissident, right? You ever had anybody in the ministry that might decide to do that? So that's the new requirement.